Where to begin? I'm certainly aware of the concerns of the unit owners in mobile home parks. In my district, there are several of these parks, and in fact, they also probably would identify with some of the comments from the good chairman of the Housing Committee as folks that had a recent purchase of their park by a larger, maybe even out-of-state corporation who has changed some of the terms and policies. And while I'm certainly sympathetic to their situation, we have to remember what our role as a state government is and what our responsibility is. You know, the role of government is not to determine who deserves what rights and who does not. Our job is to protect the rights of all of the people that we represent. That's our number one responsibility. And I am saddened each day that we come into this chamber and pervert the protection of rights into picking and choosing winners and losers, choosing one side of a transaction, and effectively dividing people into categories based on their circumstances. We divide employers from employees instead of trying to encourage those folks to work together for their mutual benefit and the benefit of our society. We divide housing providers from tenants, which they are making a voluntary agreement with one another for their mutual benefit. But once the government gets involved and starts to interfere with these private transactions among free citizens, we create problems. And those problems don't go away. And almost every particular problem that we can look at when it comes certainly to economics within our society, you can most certainly track it back to some government interference. You can look at the healthcare industry. I mean, why does healthcare cost what it does? Why does healthcare insurance cost what it does? It's because of government interfering. The COVID pandemic was an invitation, effectively, for government to interfere like crazy in every industry, including the housing industry, and we are still suffering the consequences of that interference. The bill that's before us is not fair. That's how I want to start it. Because I think the whole argument in favor of the bill is, well, it's fair. It's fair. We have to help these people. Look, no one wants to help people more than me. The way you help people, though, is not to rig the game in favor of one person over another. The way to help people is to provide everyone with freedom and protections for their rights that they have naturally from their Creator. Interfering with those rights, choosing who's going to benefit and who is not going to benefit in any transaction is not fair. That's the exact opposite of fair. Little children know what fair is. When you have kids on the playground playing and arguing or disagreeing over something, and there is a dispute, they all know what fair is. They know that if little Johnny actually was responsible and did his work, he deserves to get the treat at the end. Little kids don't think that it's fair to give little Johnny and little Bobby both treats if Johnny did his work and Bobby didn't. They get that. This government, under this majority, forgets that every day because they're trying to redefine fair into benefiting whatever group they feel is more valuable to them as a political implement to employ in the next election. I don't believe in that. I don't want to divide people. We have way too much division already. Our country is more divided than ever. People are being divided by race, by gender, by their feelings on the LGBTQ community, by geography, by the town they live in. We are divided ourselves by the fact that we live in the state of Connecticut versus other places that might have less taxation and more freedom and more civil liberties. And in the bill before us, there is a target on the back of a specific group of people, and that is those folks that have come into possession of a mobile home park. And they are the target in this bill. And at the end of this debate, if this passes and goes to the House and passes, they will have less rights. That's what happens here. Make no mistake about it. This bill is not about empowering anyone. It is about depriving the rights of a certain group of people, because that's all government can do. We are born with the right to pursue happiness. Our job as senators is to uphold our oath of office and defend that right. But when we don't defend it equally, and we pick some group to benefit at the expense of another, we are failing in that oath. And I refuse to, Madam President. I am not going to fail in my oath. I am going to stand here every day and do what is right, and not pick winners and losers, and not decide that one group is worthy of more benefits than another or more rights than another. Let's talk about the bill that is before us, and we can get into the details of just how it makes things unfair. In the very first section, when you move down to lines 29 through 31 of the amended bill, the definition is modified. It used to say owner, and now it's being changed to park owner or owner in the bill. And it says means a licensee or a permittee or any person who owns, operates, or maintains a mobile manufactured home park. I just want to ask through you, Madam President, how can someone who simply operates or maintains a mobile manufactured home park be considered to be a park owner or owner? Through you.
Thank you, Senator Moore.
Through you. Would you clarify that question, please, Senator?
Senator Sampson.
Thank you, Madam President. I'm asking about the definition in Section 7, subsection 7 of Section 1, where it defines park owner or owner to mean a licensee or permittee or any person who owns, operates, or maintains a mobile manufactured home park. Owns, I understand. An owner is the person who owns the property. But why does it include operates or maintains? Through you.
Senator Moore.
Through you, I believe there are associations who sometimes are not the direct owners, but who are representing the parks.
Senator Sampson.
Thank you, Madam President. So this definition is designed to represent the owner of the units, or the owner of the park, or the association, or all three. Through you.
Through you,
Senator
Madam President, I believe it represents the owners of the park, not the units.
Senator Sampson.
All right. Thank you very much for that answer. So owner, by this definition, includes owners of the park itself, not the unit owners. Just following up, do we know why it includes operates or maintains? I would assume that the owner is the owner regardless of whether they operate or maintain the park. And if they're hiring someone else to operate or maintain the park, those folks are still not the owner. The owner is the owner. So I'm just curious why that language is included. Through you, Madam President.
Senator Moore.
Through you, Madam President. The owner may not be a resident of Connecticut, may not be here, but hires an association to oversee, or a property manager to oversee the property to do maintenance. They are responsible for the people who have the facility, who have the units, do not own the land. The landlord owns the land, and the association, in many cases, oversees some of that property.
Senator Sampson.
Thank you, Madam President. I appreciate that information, but that respectfully is not an answer to my question. Because if we're referring to the owner of the property, the landlord, as was just mentioned, they're the owner, regardless of who is maintaining or operating it. And the reason why I ask is because the word owner is the operative language in Section 2, which is the meat of the bill. And we'll come back to the definition in my questions here. It says, Section 2, new, effective October 1st this year, any owner of a mobile manufactured home park who intends to sell, lease, or transfer, those are good words we should ask about too, land used as a mobile manufactured home park to any person except a sale, lease, or transfer governed by a separate section, shall give written notice to the owner, again, of each dwelling unit. So having a definition for the word owner and then having that definition directly contradict the language in the bill, I think is problematic, because the first owner here that we are describing is indeed the owner of the park. They are not the operator or maintainer of the park necessarily. They are the owner. And then it says, shall give written notice to the owner of each dwelling unit. But according to the definition of owner, they would have to own a mobile home park. It doesn't make any sense. So I think that someone made a boo-boo when they drafted the bill, and they should have been very specific about which owners we're referring to and the qualifications to be an owner. It also says, an owner of a mobile manufactured home park who intends to sell, lease, or transfer land used. So this applies, the bill that's before us is designed effectively to suggest that anytime somebody who owns a mobile home park intends to sell it, they have to involve the unit owners in that process. But if they intend to lease it, what would that look like, through you, Madam President? How could a unit owner lease the park? I understand that they lease the individual lots to the unit owners, and that makes perfect sense, but do all of the unit owners have to know when the owner of the park leases a unit to another one? According to this bill, it looks like they may. Through you, Madam President.
Senator Moore.
Through you, Madam President. The land is owned by the park owners. The units are the individual houses that people live in. The land is maintained by the park owner. The units are not taken care of or maintained by the park owner. If they are going to sell the land, because that is all they owned, that's what they would be, that we're speaking about in this bill. Selling the land to someone else. Through you, Madam President.
Thank you, Senator Sampson.
And thank you, Madam President. And I appreciate that answer. I don't think the good chairman's following me. I understand completely if the land owner is selling the land, and they have to let the unit owners know that's happening for the process of this bill. But it doesn't just say sell. It says lease. So if they're going to lease any part of that land, does that mean they have to tell all the unit owners? Through you, Madam President.
Senator Moore.
Through you, Madam President. In the very beginning, it says that they have to notify the unit, the members who live there, in writing that they plan to sell the property, the land.
Senator Sampson.
Thank you, Madam President. The line that I'm referring to is line 48. And it does not simply say sell. It says sell, lease, or transfer. And this is very important to me, because what we're talking about is the responsibilities that we're going to put in law on the people that own these parks. And if there is something being captured in this bill that we're missing, we should find it right now so we have an opportunity to fix it.
Madam President, could we stand at
Moore.
ease for a moment, please?
We can stand at ease
Thank
for a
you.
moment. Senator Moore.
Yes. So it's my understanding, Madam President, through you, that any owner of a manufactured park who intends to sell, lease, or transfer the land has to notify the unit owner. I hope that answers his question.
Senator Sampson.
Thank you, Madam President. Yes, that's exactly what it says in the text on lines 47 through 67. That's the beginning of it. And my question is about leasing. Again, selling makes perfect sense. If the landowner is going to sell the property, this bill is designed really to give the opportunity for those unit owners to make a purchase. I get that. But now we're talking about leasing. The only leasing that is going on is the landowner leasing the individual lots to those unit owners. So what I'm reading here is that anytime the landowner is going to lease a lot to a particular unit owner, they have to go through this process with notifying all of the unit owners. And I don't know that that was ever intended by this bill, through you, Madam President. I don't think so. But it's very concerning because, this is an onerous process. We are including 3 different methods of notification, including personal delivery, which is a question I was going to get to. And I don't think that really was intended, that we want to make the landowner have to pay for all of this service, maybe with a marshal, certified mail, return receipt, plus another letter they have to send to every unit owner anytime they want to lease one of the lots. That's what the bill says. And I just want a clarification to say that that's not correct, even though I would need something pretty specific in the bill to point to, because that's what I'm reading here. Through you, Madam President.
Thank you. Senator Moore.
Thank you, Madam President. Through you. It says that the park owner who intends to either sell it, lease it, the land, because they don't own the units, they only own the land, so they're leasing to land to another person, or transfer the land to another person. It is not about the units. It's about notifying the people who own the units, whether you own it as the park owner, whether you've leased it from the park owner, or you plan to transfer it. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. And I don't mean to keep asking the same question over and over again, but it doesn't sound like the chairman has an answer for my question. The leasing that is done is between the landowner and the unit owners. That's what leasing is done. Okay, so if I own a park that has 50 units and I'm going to lease one to Senator Martin, under this bill, I'm reading that I have to send notice to every one of the other 49 unit owners. And I have to do it by certified mail return receipt, first-class mail, and personal delivery, which may be costing me God knows how much for each one. That's what it says in the bill. And if that's not what is intended, I recommend that we alter this bill so it doesn't. Through you, Madam President.
Senator Moore.
Through you, Madam President. I want to be very clear. You can be the park owner, and you could lease it to someone else, the land, and then they would have to notify either if you've leased the land, or you're the owner, any one of those conditions, or you transfer the land to someone else, you have to notify them. I'm not sure what else I could give you to define a lease. If I had if I owned a house and I gave the lease to someone else, then they are the ones who are owning the property through a lease through me. We are not talking about the units, we are talking about the land. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I'm well aware that we're only talking about the land, through you, Madam President. To the Madam Chairman, I want to just explain, it says lease, and we are leasing the land as the owner to the unit owners, right? Let's break this down. Does that happen? Does the property owner of the entire park lease the land to the unit owners? Through you, Madam President.
Senator Moore.
Through you. The lease is the lease of a lot within the mobile manufactured home park to a person who will live in a mobile manufactured home on such lot. That's in the definition.
Senator
And the
Sampson.
bill doesn't apply to that.
Sorry, Senator Sampson.
I'm sorry,
Yeah,
Madam
go
President.
ahead. All right, Senator Sampson, I think we're on you.
Thank you very much, Madam President. Yes, exactly. So we have just confirmed that the landowner, the park owner, is going to lease individual lots to unit owners, right? This bill says any owner of a mobile manufactured home park who intends to sell, lease, or transfer, we didn't even get to transfer yet, that's a whole other set of questions, used as a mobile manufactured home park to any person shall give written notice to the owner of each dwelling unit. So that means that any time the park owner wants to lease one of those lots, they have to notify everyone. And again, I don't believe that that was what was intended by this bill, but that's what it says in the language. And I will say once again, we ought to fix it. If we want to pause for a moment and draft an amendment to correct that language, that might be a good idea. Because right now, the bill is going to require that landowner to send notification to every unit owner every time they lease one of the lots. And it's not just notification, they're being asked to notify in 3 ways. I mean, first class mail, no big deal. You send a notice, hey, we rented unit, lot 41 to all the unit owners during the mail, during the next billing or something. And even, certified mailing, although obviously that's going to end up generating a cost, which is going to increase the cost of the rents for the park. I don't think we want that. But finally, the service. It says by personal delivery. That means, are we asking a marshal to go out and do that every time a lot? That would make an unbelievable expense for the landowner, and therefore costs passed on to the individual unit owners. The whole point of this conversation is to protect the unit owners. That's why we're supposedly doing this bill. So driving up the costs exponentially on the landowner doesn't make any sense. Again, Madam President, I don't want to beat a dead horse, but unless we can come up with a way of something that is being missed in the language, that's what the bill says. And I recommend that we pause and attempt to fix it. Thank you.
Thank you, Senator Sampson. Senator Moore.
Madam President, I reject that offer. Thank you.
Thank you. Will you remark further on the bill? Senator Sampson.
I still have the floor, Madam President. I just sat while we were waiting for a response. That's all. Okay, well, let's talk about transfer then. So it says sell, lease, or transfer. So we have just established that we're putting an onerous burden on the property owner of the park, so that every time they lease one of the lots, they have to go through this process. How about transfer? Does this mean that any time the property owner of the park wants to transfer is the operative word, but I'm looking for examples. Certainly selling it would be a transfer. Leasing we just covered would be a transfer. But what if the park owner wanted to transfer a portion of the park? Maybe they want to sell off a small bit of land. I suppose that would be captured under sell. Maybe they want to give a portion of the land to somebody who works for the company. Would that be captured under transfer through you, Madam President?
Senator Moore.
Through you, Madam President. Madam President, I'd like to ask my ranking member to please look at line 136, that section shall not apply to line 145. The lease is the lease of a lot within a mobile manufactured home park for a person who will live in a mobile manufactured home of such lot. Does not apply.
Senator Sampson.
Thank you, Madam President. Where are you directing me?
To line 136 and all of the things after that it does not apply to.
Well, I'm looking under line 136. It just says the section shall not apply if. And I'm looking for an exclusion that would cover the unit owners.
Do you see line 140 on and what it does not apply to? Through you, Madam President, I apologize.
It would be covered under section 5, it appears. The lease is a lease of a lot within the mobile manufactured home park. Well, there we go. We got it. Thank you, Madam President. I'm glad we found a response to that thing because I was very concerned about what was being covered there.
Through you, Madam President, I'm also very glad that we found it also.
Very-
Well,
Senator Sampson.
thank you, Madam President. In fairness, the issue really is that this bill has been in limbo for some time, and I got this bill notification that we were going to run this bill just early this morning, and in fact, I was told it wouldn't be till 4 o'clock. I wasn't even quite done looking through it, and had to run in the room to begin to debate the bill. And my concerns still remain because we are still talking about putting a rather onerous requirement on the landlord, the property owner. Is it really intended that we want the property owner to have to send notifications in 3 separate ways anytime there is a sell, lease, or transfer? Through you, Madam President?
Senator Moore.
Through you, Madam President. Madam President, I appreciate that you didn't have very much time to my ranking on housing, but we had been negotiating this bill, I guess, for over a month and a half. A lot of it did not change. The only parts of this that changed was some of the negotiations between the buyers and the sellers to make sure that we're meeting both their needs. So this is the same bill that we spoke about in housing at length. And I really want to respect the associations that oversee the residents and the people who would own the parks that would consider selling them. That we worked really hard and negotiated a long time, and I let them work it out and didn't step into it, but made sure that I listened to all of their wishes. And this is what we've come out of this bill. They're what they would like to have.
Senator Sampson.
Thank you, Madam President. And I appreciate the good chairman's comments. However, I was not part of that conversation. No one invited me to participate in any sort of negotiation. And in fact, I would have immediately said that it's completely improper for the state government to be in the midst of a negotiation between unit owners and a property owner in a real property transaction that has nothing to do with the state of Connecticut. And that we are inserting ourselves into a transaction in an unfair way, as I stated from the outset. We're picking winners and losers, and we're choosing one side over the other in this bill. And I see we as the collective we, and I don't include myself, because I would never interfere with someone's civil liberties in this way and deny them the right to sell their property or dispose of it the way they see fit. It's their property. This isn't under one of those bills, Madam President, where I walk in here and I go, who do you think you are? Who do you think you are that you can go and tell someone who may have worked their entire life or their family for generations run a mobile home park to tell them how they have to dispose of their property? That would be like someone telling the unit owner that they can't sell their unit that's worth $100,000 for $100,000. They only have to sell it for $50,000. That would be wrong, right? We'd all agree that was wrong. Or they can't give it to a friend of theirs, or they can't sell it at a discounted rate to their coworker. That's what this bill effectively does to the property owner. It says you don't have the right to dispose of your property. You're going to do it the way we say because we know better. That's not America, Madam President. That's not how this country works. This is a place where we're supposed to protect the rights and freedoms of our constituents. It's not a place where we say, your rights matter than your rights, so we're going to write a bill that says so. It's fundamentally wrong. And anyone that believes that people have natural rights and they should be protected and they should be treated equally, regardless of whether they're a unit owner or a property owner, can see that. So back to my question, do we really want to require these 3 forms of notice? Why is it so important that we not only require the property owner to just send a first-class letter, which to me seems sufficient, to just include in the monthly rent bill, by the way, we have received an offer on the property, and if the unit owners are interested, to contact us. They could do that very easily. Presumably, those people all get their rent bill in the mail, but this goes way beyond that. It says not only that, you also have to have certified mail, which might be reasonable. I can get that. I could get past certified mail with a return receipt. But then it says personal delivery. Through you, Madam President, a follow-up to, are we really doing all three kinds of delivery? Is the third personal delivery, does that require a sheriff? Is that like service? Through you, Madam President?
Senator Moore.
Through you, Madam President, let me step back a moment and just clarify that I was not involved in negotiations. What I did do is sat down with both the sellers and the buyers to ask them, is this something that we can work with? To make sure that when I step out here on this floor, that I'm representing both the buyer and the seller and with their desires. Never did I insert myself or make any type of offer or promise. But I do want to say that everything we do here is a negotiation, because none of us all agree on the same thing all the time. And it is about negotiations. So I want to clarify that. And yes, it was negotiated, and that's what they requested, to make sure that people were notified properly, that it's 3 pieces of notification.
Senator Sampson.
Thank you very, very much, Madam President. And the other part of my question was the third piece, the service piece, the personal delivery. Is that through a sheriff or some other personal delivery? When I see it in a bill, means that you're asking someone to actually provide a hand-to-hand direct service to that person. Am I correct that that's what's in the bill? Through you, Madam President.
Senator Moore.
Through you, Madam President, it is not defined on who should deliver that.
Senator Sampson.
I understand there's no definition in the bill for personal delivery, but is there a definition in law that would clarify what personal delivery means? Through you, Madam President.
Senator Moore.
I apologize, Madam President, if I could have the good senator repeat that question.
Senator Sampson.
Thank you, Madam President. I certainly don't mind at all repeating the question, and that is regarding personal delivery. Those are the words used on line 53 and possibly other places in the bill. I understand there is no definition in the bill that is before us, but is there a definition in statute that would guide us as to what personal delivery means? Through you, Madam President.
Senator Moore.
Through you, Madam President, I don't believe that there is.
Senator Sampson.
Thank you, Madam President. So the unit owner the property owner paying any random person to go and deliver the notification personally to the person would suffice for this section. Through you, Madam President.
Senator Moore.
Through you, Madam President, it just means that the notice has to be physically delivered. It doesn't designate who has to do that.
Senator Sampson.
Thank you, Madam President. Why does it specify personal delivery? We've already covered delivered under certified mail with return receipt. We've already covered first-class mail with tracking as 2 other forms of delivery. Why would we specify personal delivery if it wasn't intended to be more official and in person via a sheriff or some other type of lawful service?
Senator Moore.
Through you, Madam President, I don't think more would hurt. I don't think that personal delivery would take away, but it would just be another layer. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I'm just going to state for the record that I think it's quite clear that personal delivery means paying a marshal for service. I mean, I think that's what the bill means. And until I have something that says otherwise, there's no reason to specify personal delivery unless that's what's intended. It says, because it's not any of the 3, it's all 3. All 3 things are required. Shall give written notice to the owner of each dwelling unit by certified mail with a return receipt requested, by first-class mail with tracking, and, not or, and by personal delivery. So it's not just that it has to be delivered. The words in the bill actually mean something. And the way that we operate in this country is via the rule of law. And that's what we're doing here. We're making laws, and we're putting these words into statute. And a judge is going to have to someday be able to interpret that. And it's very clear. We are telling folks in the world that our law will require all three means. And to state personal delivery means service. I'm going to just move on because I don't know what else to do. It's very frustrating that we have a bill before us. The plain language text is right there. And I'm simply trying to clarify that this is what was intended, because I find it just bizarrely aggressive in this particular case. I don't think there's a reason to include lease and transfer in this conversation, where it's a conversation about selling. I don't think there's a reason to require all these forms of notice, more than one, and I certainly don't see a reason to require personal delivery, because it's costly. And as I mentioned, every cost that is imposed by the bill that's before us on the park owner is going to get passed on. It's going to get passed on to the unit owners. That's not what we want, right? So I don't understand why we're continuing to make the bill as oppressive as it is. It doesn't have to be this way. And then it says, such notice shall contain, include the statement advising the recipient of the notice of the intended sale, lease, or other transfer of the park. And then it says, a statement of the resident's rights under this section. So now we're telling the unit owner that they have to tell the resident, or excuse me, the property owner, we're telling them that they have to provide the unit owner with their rights. Since when are we telling somebody who is not an employee of the state of Connecticut or any state agency or anything else, they are just a private property owner that lawfully owns property, who should be able to sell it to whomever they want for whatever they want, or give it away, or do whatever? Cease to be a mobile home park. They should be able to do whatever they want with their property. That's how property rights work in America. Now, they're obligated by contract to all of the unit owners, but only for the terms of the contract. The contract was voluntarily entered into by all the parties. I'm going to lease you this property. I'm going to lease this property from you. We sign. That's the term. Once that term ends, the agreement ends. So I'm not suggesting that property owners don't have an obligation to the unit owners. They absolutely do. And I would be the first person here to jump up and down and say that something's wrong if they're not actually living up to those contracts. But what we're doing here is we're interfering with their ability to use their property the way they see fit. It would be wrong if we took any other group of people. We can just name any group of people. If we said to churches, or we said to people whose names start with the letter A, you don't have the same property rights as other people, you don't get to dispose of your property the way that other people can, it would be wrong. And that's what we're doing here. We're saying that these people don't have the same right to do with their property. It doesn't matter whether they worked their whole lives for it. It doesn't matter whether it was passed down through generations of hard work. It doesn't matter if they want to actually sell it to someone who has worked for the company for 25 years at a discounted price. They don't get to do that anymore. This bill takes that right away from them. It takes that right away from that other person, too. It's a bad bill. And now we're also imposing on that property owner to say that they have to provide the statement of the unit owner's rights. Why is that their job? Through you, Madam President.
Senator Moore.
Through you, Madam President. Madam President, we're establishing for the first time laws that will allow the people who live in the units to purchase property. We've tried to put into this bill what we believe needs to take place to make sure it's fair and equitable for both sides. So we're establishing that law. If I'm establishing something and we're trying to put all the strengths that we can in the bill, we do all of those steps, right? So I want to go back to the piece on the mail. It does no harm for someone to deliver something personal, but it's actually in current law that it has to be first class or personal delivery. So I just want to be clear. We're creating this law to strengthen the negotiations or the contract between the buyer and the seller, and that's why that's in here.
Senator Sampson.
Thank you, Madam President. I would just like to, I have great respect for the chairman. I do not want to engage in calling points of order and so forth. But if we want to go through this bill together, I have questions. And I would just like to, if possible, get answers to my questions. I'm not going to interfere with the right of the chairman to speak as long as she wants on her opinion about the bill. But this is my time to talk about what I feel about the bill and express my concerns and ask my questions. So I hope we can stick to that going forward. Although I certainly appreciate the give and take, I have no problem with that. Again, no disrespect intended, but there is a process that we're supposed to follow here. I'll just respond respectfully by saying the current law in other places might say first-class mail or personal delivery. This does not say or. Through you, Madam President, it does not say or. It says and. It says all three types are required. And not just for sale, but also for lease and also for transfer. And I presume that means if they want to transfer any portion of the land that they own, even if that land doesn't even have a unit on it, or if that land has one unit on it, maybe they want to say to one specific unit owner, I'll sell you your lot. They would have to go through this process. And that's a concern. Where were we? We got kind of sidetracked because I was asking a question about the rights. What are the rights that the statement of the resident's rights under this section that the property owner would have to send to them via those three methods? Through you, Madam President.
Senator Moore.
Through you, Madam President. It would be the rights of the association to go through what are the process and the steps for purchasing the property, and to understand that the property is now available for sale. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I appreciate that answer. And that's a perfectly good answer, although I was hoping to get something a little more specific, because I can just see myself or any other person who's in this position saying, okay, the law is telling me that I have to send a statement to the unit owners about what their rights are. First off, I'd be asking myself, why am I doing this? The state of Connecticut is not my employer. They don't have a right to tell me what to do. They don't get to ask me to enforce their law. The state should be enforcing their law. The state should be informing people of their rights under this section, in my opinion. And I'm concerned that they would consider this to be a legal trap, that if you fail to include something in that document, that you could be sued. And if you went through the whole process and sold the unit or the land to another buyer or to the unit owners, you might have a legal claim filed against you that you did not completely and satisfactorily issue a statement of the resident's rights. Is there a potential here for legal liability if the property owner does not provide a statement of the resident's rights? Through you, Madam President.
Senator Moore.
Through you, Madam President. I don't see anything that said that there is, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President, and forgive me, I didn't catch the answer. I'm wondering if the good chairman would repeat it. Thank you.
Through you, Madam President. I said I didn't see anything here that says that there is.
Senator Sampson.
Thank you very much, Mr. President. I caught myself very quickly there. Had to switch over. And I appreciate that answer. I don't see anything in here that is either, but that's not how liability is created in the world. Liability is created by, a requirement in the law being omitted and having an impact on someone else's financial status or something where they have damages. And I can see that happening in this particular thing. Is there anything that we could do to protect the property owner to make sure that they are not going to become in trouble with the law if they, in good faith, try and issue a statement of the resident's rights but fail to do what is completely required by the section? Through you, Madam President.
Senator Moore.
heard you say something. I was saying, I think the Lieutenant Governor's voice has changed a bit. Through you. This is written in good faith between the buyers and the seller. And if they choose to have an attorney or someone come in and step in legal, they could.
Senator Sampson.
Thank you, Mr. President.
I'm sorry. I apologize.
I apologize. Senator Moore.
Thank you. So actually, on line 126, it says the park owner and the park residents shall at all times have the duty to act and bargain in good faith with each other.
Senator Sampson.
Thank you, Mr. President, and thank you, Madam Chairman. I got to get all my misters and madams correct. I appreciate that, and I did see that section. I have a question about that when we get to it. The fact that they have a requirement to act in good faith is separate from my question, which is, can someone become personally liable, and is there any protection or penalty in this section? But I won't ask the question again. It's not spelled out in the bill, but I do see that as a concern, is that we are potentially creating a pitfall by making a requirement on a private citizen that we almost never do. We don't ask private citizens to inform each other of the law. We don't do that. It's not their job. And we don't go around saying, Senator Seminar, you have to make sure that Senator Kissel knows that he has to stop at traffic lights. That's your job today. We don't do that. We don't tell private citizens to inform other people of the law or their rights. We don't do that. And when we put that in a bill, you're creating a situation where now, if someone fails to follow this law, they could become liable, in my opinion. And because it's not specific, it does not say in here what those rights are in particular. There's no form, for example. I think it might have made more sense to have something in the bill that says that the Department of Housing will create a form establishing, the proper notification, or maybe even put it on their website what the rights of the unit owners are. That would make much more sense, because then it would be public, for one, and people would know what it is. Much more traditional, and I think appropriate for this context. Asking the seller, and again, at this point, there's no sellers and buyers. I just want to make that clear too. No one's reached the point of seller or buyer here. We've only got someone who is offering their park for sale, potentially, it says intends to sell, lease or transfer. Well, I just want to point out that that captures everyone, because everyone intends to sell, lease, or transfer their property. Because no one lives forever, and therefore you intend to transfer your property upon your passing, potentially. And let me just ask that question, since we're on the subject of transferring and these rights. If a park owner passes away and they have a will that says that they are going to transfer the park to another party who is not a family member, because I know that's covered, how does that work in this bill? Would this notification have to take place, first off? Through you, Madam President?
Senator Moore.
Madam President, can we stand at ease for a moment?
We can stand at ease.
There is an exclusion on line 140.
Senator Sampson.
Thank you, Madam President. Is it the good chairwoman's opinion that line 140, where it says the transfer is by gift, device, or required by operation of law, would include someone's property passing by will or through the probate court to a non-relative? Through you, Madam President?
Senator Moore.
Through you, Madam President, devise includes will.
Senator Sampson.
Well, through you, Madam President, I would simply say a contract is a device also. So my concern about that sentence, now that we look at it too, is it doesn't look like it was written very carefully either, because if the transfer is by gift, device, or required by operation of law, So I think that's another concern, that we have inserted the word device there as an exception to this. But I won't dwell on it. I just think the whole bill is written this kind of way where there's little attention to the notion that words matter in this particular proposal. And for the record anyway, and for legislative intent, let's just confirm that one time, that someone would be able to transfer their property at their time of passing to someone else without falling into this requirements of this bill. Through you, Madam President.
Senator Moore.
Through you, Madam President, I agree, and also for legislative intent.
Senator Sampson.
Thank you very much, Madam President. I appreciate that. That was very good to get that on the record. So the next part of this goes down to the price, terms, and conditions. So when it says that the owner of the mobile manufactured home park who intends to sell, lease, or transfer has to provide notice in the three forms we discussed, it says they have to include the price, terms, and conditions of any offer the park owner has conditionally accepted or plans to accept, which to me is kind of vague too, because I plan to accept an offer of $10 million for my $500 car. But I don't have anything that actually puts that into play. And that's the way this bill, unfortunately, is written. It should only rely on conditionally accepted offers. But that's neither here nor there. My question is about conditions. What does conditions mean? The price, terms, and conditions. Is that all inclusive, through you, Madam President? What does conditions include?
Senator Moore.
Through you, Madam President, it includes all three that was mentioned.
Senator Sampson.
Well, then get it back to me. Through you, Madam President, I'm sorry.
No problem.
We're trying to find an amendment, and I apologize that there's some side conversations going on. I would ask for the gentle lady to repeat the answer to my question. Through you, Madam President.
Certainly, Senator Moore.
Through you, Madam President, conditions includes anything else that the buyers and sellers may need to negotiate.
Senator Sampson.
Thank you, Madam President. When you say anything else, is that any other part of the contract? Through you, Madam President.
Senator Moore.
Could we stand at ease for a moment?
We can stand at ease. Let's go ahead.
Thank you.
Senator Moore.
I first want to say that this is modeled after legislation in 17 other states, but it gives specific conditions and offers, so whoever the buyer is, that they'll be completely aware of anything that's being negotiated.
Senator Sampson.
Thank you, Madam President. So the seller is required to provide all of the conditions, effectively the entire contract. So that would mean the contract certainly would include a price. It would also include, what exactly is being conveyed. Whether it's the terms of the property, the deed itself, but also anything else that might be part of the transaction, that the seller agrees to remove, some dead trees. God knows what could end up in a real estate transaction. And is it my understanding correct that the reason why we are putting these conditions down in writing for the potential purchase by the unit owners is so that they have the ability to review and match such an offer? Is that correct, through you?
Senator Moore.
Through you, Madam President, I do appreciate your knowledge, and you are correct.
Senator Sampson.
Thank you very much, Madam President. I have two very, very important questions on this subject. The first one is probably the one I should do second, but because it's so on topic, I'm going to hit it first, and that is, there is one condition that we are putting on the seller by virtue of the policy that is before us that will not be on the unit owners, and that is the condition that the seller has to give an opportunity to the unit owners to make the purchase. That is something that will not inure to the benefit of any other person that wants to make an offer. So no matter what, these offers will never match. And that's probably the number one issue I have with this bill. Aside from the fact that, as I stated from the outset, it's not fair. It is effectively choosing one side of this transaction to give an additional benefit to. It also undermines everything that we have become accustomed to in real estate law. I've been a realtor for, 20 plus years in Connecticut. We have other realtors in this room. Generally speaking, when people exchange real property, many times it's done in secret. It becomes a public record afterwards. But if someone wants to sell their property to another person, that's no one's business. They don't have to tell anyone. And they don't have to set the price to be fair with the market. They don't have to give other people an opportunity. If I want to sell my property to you, Senator Moore, at half the price that I would sell it to anyone else, that's up to me. It's not up to anyone else. It's my property. And the thing is, I want to just pause for a second and say, if there's anybody, who is in the listening to this conversation or following this policy making as a unit owner, they need to understand, I have no issue with them. I have an issue with this place. I have an issue with the idea that the government would think that it's okay to jump into your situation to your benefit or to your negative benefit. We just don't have a right to do it at all. That's my problem here. And we don't have a right to tell the property owner what to do with their property. The same that you wouldn't like it if somebody told you what to do with your property. And that's the important thing we have to remember here. So in real estate, generally speaking, no one has a right to tell anyone how to sell their property. And we're talking about a piece of property that is owned by someone. It's not a government-owned property. It's not even government subsidized. The government's got no role in here at all. They got nothing to say. That property is owned by a private person or entity that has the full rights of any American citizen to own property. And this bill undermines that right as directly as possible. And it does it in so many ways. Not only are we suggesting in this bill that they have to even tell other people about the sale, which there may be some element of a public benefit that somebody thought that was a good idea at one time to put that in there. And I could even maybe get around and understand that. But telling people that the property is for sale so that they can make an offer on it should not ever obligate the seller to take their offer. We don't do that ever. We don't ever say someone has to take someone's offer for the purchase of their property. And as I mentioned, it's not fair because the typical buyer that would be interested in making the purchase is at a disadvantage. So not only are we impacting the rights of the seller, we're impacting the rights of every other buyer that could exist. And most importantly, you're undermining the nature of the transaction. Because the transaction is a dishonest one. It can only be an honest transaction if everybody has an equal footing to make a bid. But there's no equal footing here because the first buyer that approached the seller and said, I want to offer you X for your place, is at an automatic disadvantage in this bill. Why would we deprive that person of their right? I heard the chairman mention at the outset, it was these big corporations from out of state. Well, we don't distinguish between big corporations out of state, small corporations in state, or anything else when it comes to the right to make a purchase or the right of a seller to sell something. We don't do that, and we should not start here and now. So when you say that the conditions are going to be indicated. How about a typical condition that is in every real estate transaction I've ever seen, which is a condition that says an offer must be accepted in a certain amount of time? What if the seller puts that in their offer? Through you, Madam President.
Senator Moore.
Thank you, Madam President. Madam President, in the legislation, there is a timeline. It's 45 days of notice of intent, 45 days to sign and purchase the agreement, and 180 days. If the agreement isn't handled or there's no sale in 180 days, the negotiation ends.
Senator Sampson.
Okay, but I'm reading lines 64 through 67. It says, a park owner may accept an offer for the sale, lease, or transfer of the land before providing a copy of such notice as long as the agreement is conditioned upon giving the residents the notice and opportunity to purchase required by this section. Okay? That is in direct contradiction to the other section that says that they have to meet the same conditions. Because they don't have to meet the same conditions, because the first sale has a condition that is being added right here. Through you, Madam President, are we not adding a condition to the original sale in line 64 through 67? Through you, Madam President.
Senator Moore.
Maybe stand at ease, Madam
We
President.
can stand at ease for a moment. Senator Moore.
So, Madam President, according to lines 64, it says a park owner may accept an offer for the sale, lease, or transfer to the land before providing a copy of such notice, as long as the agreement is conditioned upon giving the residents the notice and opportunity to purchase required by this section.
Senator Sampson.
Thank you very much, Madam President. My point is they cannot accept an offer because the offer has a new condition. The condition created by the sentence that was just read, which is that that buyer has to live up to this condition, that the place has to be offered to the unit owners. So later on in the bill, in subsection D, where it says that if the association and the park owner cannot otherwise agree upon a purchase price for the park, the association shall have the right to purchase the property upon the same price, terms, and conditions of any existing bona fide offer to purchase the park made by another potential officer, or potential, not officer, by another potential purchaser. But that's not true, is it? That can't work, because if I have an offer on the table from someone saying that I am willing to purchase the park, but my offer expires at midnight on Wednesday, does this bill say that I can go to the association and say, you guys have an opportunity to match this offer? Through you.
Through you, Madam President, that is not one of the conditions.
Senator Sampson.
Pardon me, Madam President, I didn't hear that answer.
Through you,
Senator
Madam
Moore.
President, I said that is not one of the conditions listed.
Senator Sampson.
Well, thank you, Madam President. I don't know what you mean by that, through you, Madam President. We said the conditions were any other conditions, all the other conditions that might be in an offer. And we said everything, you know. We said it was going to be the price, the details about the property. We're missing timeline. We're missing deadline for an offer to be accepted. Those are things that are in real estate transactions almost every time.
Senator Moore. Oh, there's no question yet. Sorry.
Oh yes. Well, I suppose I could frame that in the form of a question, which is, through you, Madam President. It was said earlier that they can meet the same price, terms, conditions of any existing bona fide offer. That's what it says in lines 96 through 99. But I'm asking is if the offer includes a deadline, would the association have to meet that same deadline as well based on this language? Through you, Madam President. Senator Moore.
Through you, Madam President, no. That condition cannot be handled under this because we've set the dates of how we're going to move this as the 45, 45, and 180s. 180 days. So no, it does not.
Senator Sampson.
Thank you, Madam President. So a follow-up question. What does that do to the right of the property owner to sell their property? And what does that do to the rights of the original buyer?
Senator Moore.
Through you, Madam President. Madam President, we are giving the residents the right of refusal, be the first person to refuse the property. And those are the conditions that we've decided upon or agreed to. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President. This is not the first right of refusal that we're talking about. A first right of refusal is when you go to someone and say, would you like to buy the property for my price? And they say yes or no. That's offering someone the first right of refusal. That's what that means. This is not that. This is saying that you're requiring the owner of the property, the person who owns the property. I'll just keep phrasing it that way to make sure it sinks in for everyone. It's their property. It's not ours. It doesn't belong to anyone else. It's theirs. We're telling them that when it comes to their property and they have someone who wants to buy it from them, they cannot sell it to them until they give a very generous opportunity for the unit owners to come up with an offer that is not the same. And when I say not the same, it's because it isn't the same, because it is not subject to the condition that it has to be offered to the unit owners, because they are the unit owners, and it doesn't have to live up to any time requirement or deadline. And in fact, the deadlines in this bill are absurd, in my opinion. First off, you allow up to 60 days for them to even respond to the notification. If I'm trying to sell my property and someone comes along and says, Rob, I want to buy your property, here's an offer, wait, I have to give it notice for 60 days to someone. Do you know what that does to my potential to sell my property? It diminishes it dramatically. It may cost me the opportunity to sell it, period. And then when I tell them, if the other party agrees to buy it at the 60th day, they have another half of a year, 180 days to come through with the purchase. I'm going to lose my original buyer. And maybe even more important than that, Madam President, we're going to actually diminish the potential of the offer existing to begin with. Because who the heck on earth is going to want to make an offer when that's the situation? Why would I want to make an offer on something where I know the seller chances are, can't sell it to me? They certainly can't sell it to me within 60 days, and I might end up waiting around forever so someone else can match my bid. And why would I put in a good bid, by the way? Why would I do that? It doesn't make any sense. And what about my rights as a buyer then? Why am I being put in second place? This bill is about as unfair as anything I've ever seen in this place. That's why I chose those words from the outset, because I know that's something that speaks volumes in this place. Well, it's fair. We're doing this because it's fair. It's not fair. The only thing that would be fair, and honestly, it's still not even that fair, but it's more fair, would be to say that, okay, the park is interested in selling. They have to follow the current law, which is that if they're going to dissolve the park and do it to turn it into a different use or sell it to someone who will, they have to provide year's notice for first right of refusal. That makes sense. I understand it. Those are people's homes. They can't necessarily, move on a moment's notice, and I can understand the interest behind protecting them in that regard. Although it's really their obligation to protect themselves in their lease agreement with the property owner. It's a private contract. It's another place where we've inserted ourselves. But, all right, given that's the current law, the only other thing that I can think of, Because what we're doing here is going way beyond the bounds. In any other type of property transaction, there's no obligation for the seller to tell anyone that they're even selling. No other obligation. I'm going to sell my house. I don't have to tell anyone. Even if I have a tenant, I don't have to tell them. My house, I can sell it if I want. I still have to live up to the agreement that I made with the tenant, and rightfully so. But I don't have to tell anyone. Here, we're saying not only have to tell people that you're selling, you also have to tell people if you have an offer and for how much and what the terms are. I hope my fellow realtors in this room will get up and talk after about real estate transactions and remind us that that never happens. Almost every real estate transaction, the offers are secret. The offers stay secret until there's a closing, in fact. Because what will happen is you'll put a listing up for sale, especially in this market, and numerous people will bid on it. And right now, people are bidding wild numbers beyond the asking price in many cases. And the terms matter, whether it's a cash offer, whether there's inspections involved and so forth. And I will just mention, I had a transaction this past weekend. It was a house that was listed for $450,000. My clients bid more than $50,000 more for that property. And they didn't get it. And we're still speculating on, how much did the other buyer offered, or buyers, that was better than our offer? Was it, $550? Was it $600? Who the heck knows? We'll never know until it closes. And the reason why we won't know is because if something happens in that transaction, that seller should have the right to be able to have kept that information confidential so they can come back to me. Or they can put the property back available to others and not give up their advantage about how much they were willing to accept. So we are denying the rights of sellers to determine who to sell their property to effectively market it, and to be able to sell it for its maximum value here. We're also disadvantaging any potential buyer of that property from being able to purchase it by saying that they can immediately be removed from the transaction by someone else with a matching bid, which is not required to be a matching bid. Because even if I said, look, I want to buy this park, and I will buy it cash money on Monday, but you have to give me an answer by Monday, or within 24 hours, or who knows. Certainly, that's not taken care of in this thing. Those are not the same offers. Those are not the same conditions. It's not even close. And by creating this scheme, what you're doing effectively is you're telling the seller that you are going to limit their ability to get real offers from real buyers, because you've just put every buyer at a disadvantage they don't want to operate in. Let me just say something more generally about this whole thing, which is that the whole purpose of this is to protect the unit owners, right? That's why we're here. Well, let me ask everyone how they think unit owners are going to fare in the future when you cannot legitimately buy a park. You cannot have the desire to own one any longer because you're not in a situation to turn it into a profitable asset in the future, and you can't sell it to whom you choose for the price you want. How does that help the unit owners in the future? It doesn't. That will only create more problems for unit owners. What should happen is we should try and work on making housing affordable in Connecticut by encouraging people to build property to become housing providers. That's what we should be doing. But instead, almost every policy that comes through here is a punishment to housing providers. And then we shake our heads and go, gee, why are there no properties? Why are people selling their buildings? Why are people selling their mobile home parks to out-of-state corporations? It's because it is unbelievably adversarial in Connecticut to be a property owner. The state of Connecticut has got it out for you. They want to make your life difficult. So these property owners are like, you know what? I'm going to go to find greener pastures. I'm getting out of here. And that has to do with a lot of policies that we pass, not just the ones specific to housing. I'm going to offer a couple of amendments, Madam President. The first one is, actually both of these amendments are opportunities to do what's right. That's what we're doing here. The first one is LCO 9133. I ask that the clerk call it and I be given leave of the chamber to summarize.
Mr. Clerk.
LCO number 9133, Senate Amendment B.
Senator Sampson.
Thank you, Madam President. This amendment keeps some of the underlying bill, which I've already made clear I don't agree with, the notion of the seller having to give up their position in the transaction by providing notice to anyone. It's not their obligation because it's their property, but it retains that and simply changes this scheme of requiring the seller to give the unit owners an opportunity to match a buyer's offer and to carry that transaction out for more than 6 months. The whole market can change in 6 months. And instead, what it does is it says if they get an offer, what they've got to do is they have to give an opportunity to the unit owners to make an offer to purchase. And that's more than most people get in most real estate transactions. This at least gives them the opportunity to say, look, we found out that the park owner is going to sell, and we have an opportunity to make a purchase so that they can go through the process of whatever they want, to go and try and get financing or contact with the state of Connecticut or something like that, which we'll be talking about in the next amendment. This is the right way to fix this problem. This gives them an additional opportunity to make that purchase, but it doesn't put a burden unfairly on the park owner other than to require him to include a buyer he may not have otherwise included. But it does not obligate him to choose any particular buyer. And this is the right way to go about it in a free market situation. I move adoption of the amendment, Madam President, and I'd like a roll call vote.
Thank you. Will you remark further on the amendment before the chamber, Senator Martin?
Thank you, Madam President. Madam President, I just rise to ask the proponent of the amendment.
Please proceed. Senator Sampson, prepare yourself.
Thank you, Madam President. Through you, Madam President, I was not able to hear the amount of time that the tenants would be able to respond to that offer to make an offer. Through you, Madam President.
Thank you. Senator Sampson.
Thank you, Madam President, and I appreciate the question. I thought long and hard about this amendment, and I tried to make it as appealing to the majority as I possibly can. In the real world, I would have said a very short period of time. I know Senator Martin is also a realtor, so he knows that when somebody says make an offer on my property, usually that means like now, or within a couple of days. But this bill, this amendment would follow the same terms, which is 45 days for a period before October 1st, 2025, and 60 days for a period after. So they would have a lengthy period of time to be able to come back and make an offer on the property. Through you, Madam President.
Thank you. Senator Martin.
Thank you, Madam President. So this would be a strike-all amendment, but allow... No? Okay. Through you. Could I ask the proponent of the amendment to summarize the amendment again? Through you, Madam President.
Go ahead, Senator Sampson.
Thank you, Madam President. It does not strike the entire bill. It retains much of the underlying amended bill that is before us. It simply removes the process once an offer is on the table for a seller by requiring them to give notice to the unit owners and their opportunity to make a purchase in that 45 or 60-day time frame, depending on whether it's before or after October 1st, 2025.
Senator Martin.
Thank you, Madam President. So is the time that you're providing here allow them to organize and to form an association in order to make that offer through you, Madam President?
Senator Sampson.
Thank you, Madam President. This does not require them to close in that period of time. It simply gives them an opportunity to make an offer within that period of time. And if they chose to form an association for that purpose or contact a lender, I believe that's ample time to do so.
Senator Martin.
Thank you, Madam President. Madam President, through you, from I understand this bill that this would only pertain to lots if there was a minimum of 15 lots or more. Is that part of would your amendment still include that? Through you, Madam President. Excuse me, let me rephrase that. So this underlining bill has certain exclusions into that. And for instance, the 15 lots or less, this would not be applicable. But for 16 lots or more, then the notice would have to be required from the landowner to the unit, to those that are leasing. So what I'm asking you in your amendment is if there was one tenant who wanted to buy this or make you an offer, would that be allowable? Through you, Madam President.
Senator Sampson.
Thank you, Madam President. Just in response to your first half question, this does not replace the exceptions in the bill. That remains. This simply changes Section 2 of the bill, which is all about the notice requirements after an offer is on the table for the park owner. And this refers only to them giving an opportunity to purchase. So effectively, it would allow anything to happen by virtue of the fact that all it's doing is requiring the seller to enter into the opportunity for negotiation with the unit owners. So they can make any type of offer. They could presumably offer to buy the whole park or part of it, or a single unit owner could offer to buy a single lot. And that would all be acceptable because it is now, effectively. This just creates the process through a statute by suggesting that the park owner has got to give this opportunity in writing with a certain amount of time. Through you, Madam President.
Senator Martin.
Thank you, Madam President. So what I understand here is that you're, going back to one of your comments about realtors, transaction, we do not reveal what an offer is. We could have 10 different offers, and we do not reveal the price to anybody. We're bound by our code of ethics, really. And in addition to that, should we have an offer, we are not to make that offer known to anybody until the actual closing of the transaction. So what I hear you trying or attempting to do here is to protect those rights of the owner in not disclosing that amount to the potential buyers of those that are leasing the current mobile home park. So it sounds like it's a very more fair than what this bill is actually proposing. You are protecting the owner, but you're giving that opportunity for the buyers or those that are leasing. You're giving them the opportunity to make an offer, but without disclosing the amount of the offer, which is the normal process that we do in the real estate world. So I stand here, Madam President, in support of this amendment because it is more fair. It protects the owner, but also gives the ability to the proponent of the bill, those that are leasing the property currently, an opportunity to make that offer. And that is, I think, we're trying to do is to make a level playing field. So through you, Madam President, thank you so much.
Thank you. Will you remark further on the amendment? Senator Moore.
Thank you, Madam President, through you. Because this was negotiated by buyers, sellers, advocates, and this is the terms that they've agreed to, I would ask that we reject the amendment. Thank you, Madam President.
Thank you, Senator Martin, for the second time.
Yeah, thank you, Madam President. Madam President, through you, who negotiated this agreement? Through you, Madam President.
Senator Moore, please announce the vote to the members.
Immediate roll call vote has been ordered in the Senate. An immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment B. This is for Senate Bill number 988, an act concerning the purchase of a mobile manufactured home park by its residents. An immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment B, the Senate Bill number 988. We're voting on the amendment. We are voting on the amendment. Senate Amendment B, the Senate Bill number 988, an act concerning the purchase of a mobile manufactured home park by its residents. An immediate roll call vote has been ordered in the Senate. Senate Amendment B for Senate Bill number 988. Immediate roll call vote has been ordered in the Senate. Immediate roll call vote in the Senate. Voting on Senate Amendment B of Senate Bill 988. An immediate roll call vote in the Senate.
It presents fair and
Have all the senators voted? The machine Mr. Clerk, would you like to call that?
LCO number 9079, Senate Amendment C.
Senator Sampson.
Thank you very much, Madam President. So this amendment kind of takes a different track. But again, I'm trying to be thoughtful of what we're hoping to achieve here. And my understanding is that the goal is to find a way for these unit owners to be less at the mercy of the terms of their lease agreements going forward with respect to changing market conditions or the whims of the seller, et cetera, et cetera. Now, part of me says that those are private contracts. They are in a position to negotiate lease terms. And they're in a position to negotiate lease terms for longer periods if they wish. And I'm quite certain that there are at least some property park owners that would be willing to have that negotiation because generally speaking, when you enter into negotiation on a lease, the length of time is certainly a factor that can help you if you're on the leasing end of the negotiation, because really the owner wants to have security in the fact that they have a tenant and it's going to be a steady flow of income, etc. We tried a couple of different things, but I think maybe the best way to go forward is by giving the unit owners the ability to make the purchase altogether. You know, giving folks access to information, the opportunity to make a bid and all this sounds really good, but at the end of the day, if they don't actually have the means to make the purchase, it doesn't really help. So my goal here is to try and help that situation. So the amendment that is before us is very straightforward. It strikes the underlying bill and replaces the whole thing with this simple language, effectively, that says, for the purpose of assisting Connecticut residents to purchase mobile manufactured homes to be located in a mobile manufactured home park, the authority shall set aside not less than $2 million, et cetera, et cetera. And then it says, for the purpose of assisting any association of residents of any mobile manufactured home park to purchase such park, the authority, which is CHAFA, the Connecticut Housing Finance Authority, is authorized to make loans directly to any such association upon the security of mortgage on such park. So we're going to actually use the state for its proper role rather than interfering with private contracts, denying the rights of some residents to the benefit of others. And we're going to do something much better, which is use the state as a mechanism to help unit owners finance a purchase. I move adoption. I'd ask for a roll call vote.
Thank you. Will you remark further on the amendment, Senator Moore?
Thank you, Madam President. Madam President, the way I read it, I want to understand, because CHAFA already has a program for loans that's been working for quite some time. So that's just for a point of clarification to the senator.
Thank you. Senator Sampson.
Thank you, Madam President. Yes, the Connecticut Housing Finance Authority is engaged in many different activities to help buyers of different types of real property make purchases, but this is to expand their authority to create products to purchase an actual mobile home park, not just a mobile home unit or something like that. This would allow the unit owners to work together to form an association and work with CHAFA to help secure financing to make a purchase. And I don't believe that's something that the Connecticut Housing Finance Authority is already doing, at least not as explicitly as this amendment says. And I support it for that reason.
Thank you. Will you remark further?
Yes, Madam President.
Senator Moore.
I apologize, but I'm trying to clarify that CHAFA already does that. I don't know what is different from what they do now to what you're asking. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I appreciate the question, but I do not believe that CHAFA does what the amendment hopes to achieve.
Thank you. Senator Moore.
Madam President, through you, then I would reject the amendment, believing that they already do that. I would ask my colleagues to vote against the amendment. Thank you.
Thank you. Will you remark further on the amendment? Senator Maroney.
We understand that housing is economic development, but through you, Madam President, I just wonder how this would differ from the Connecticut Housing Finance Authority's existing park purchase program that was created by Public Act 94-125.
Senator Sampson.
Thank you, Madam President. I would simply state that my goal is not about affordable housing, first and foremost. My goal is about protecting the rights of the people that I represent, and particularly from the underlying bill, which interferes with those rights. And this amendment is designed to remove those infringements and create a mechanism for people to obtain their own financing. And if the Connecticut Housing Finance Authority already has such a program, I am not aware of it. I know that there have been public acts in the past that affect mobile home parks, but this is explicit. The language in the amendment says that the authority is authorized to make loans directly to any such association upon the security of a mortgage on such park. And I think that it is a worthwhile amendment in that it gives the direct opportunity for those unit owners to make a purchase instead of simply engaging them in the ability to bid, which if you don't have the means to make the purchase doesn't mean much.
Thank you. Senator Maroney.
Through you, Madam President, I thank the proponent for his answer. Connecticut is fortunate in that we do have a program through the Connecticut Housing Finance Authority. I'm very fortunate that I represent the Ryder Woods mobile home community, a community of 174 residents that was the first in the state to have the residents actually purchase their park where they live. And I applaud them. I applaud one of my constituents, Al Riz, who's sitting up above me, because all too often when we're in this building, we see that people are fighting. They get something and they fight to protect it. Well, today you had stated that many real estate negotiations happen in private, and it's not until that they're completed that they become public and someone knows about that transaction. So through you, how would the residents even know to utilize this program if they wasn't a requirement to notify them of the opportunity to purchase their home park?
Senator Sampson.
Thank you very much, Madam President. There was a lot in that question. It was more of a speech, but I will try and answer the question, which is they don't need to have another offer on the table. The good senator just spoke for a few minutes about the benefits of the unit owners being able to purchase their own park. Why should they have to wait until there's another offer on the table? The whole point of this amendment is to give them the ability to go and make an offer and purchase their park right now. They don't need to be competing with some out-of-state corporation or anyone else. If they're in a situation where they want to go ahead and make a purchase, then they should be able to do so, and they should be able to utilize CHAFA or the other nonprofits that were mentioned. I do want to make a simple clarification, by the way, that some of the entities that were mentioned do not actually provide ownership in the park. And I would caution anybody who is a mobile home unit owner to think very hard and very carefully and look at any contract in great detail before signing up with somebody who supposedly is going to come along and allow you to become an owner. Because what those companies do often is they make the purchase on their own and they sell you back a share in their company. But that is not ownership in the park, and it doesn't enjoy the same benefits. And the data from the from the Federal Housing and Urban Development Agency shows that they very often end up with higher fees and costs than privately owned parks. So I just want to caution people. The goal here for me, unlike a lot of other folks that are commenting on the bill, is not to pick a side. I'm not on the side of the park owners or the unit owners. I'm on everyone's side in the sake of protecting the rights of all people to engage in commerce freely and to make their own choices and have all the same terms. It's not right for people to be advantaged or disadvantaged by state intervening in a private transaction like this.
Senator Maroney.
Thank you. Thank you. I thank the proponent for his answer, and I fail to see how this proposal differs from the existing programs. So for that reason, I do not support this amendment. Thank you, Madam President.
Thank you. Will you remark further on the amendment? Will you remark further? If not, I will open the voting machine. And Mr. Clerk, please let the senators know they should. Amendment fails. Senator Sampson.
Thank you very much, Madam President. That was an interesting dialogue and some debate over whether or not the Connecticut Housing Finance Authority already has such a program. And in fact, they do have a similar program to what was indicated in the amendment, which leads me to believe that we all should have supported it. I think we have all supported similar types of policy in the past. And if we can simply reaffirm that it's a good idea to use our state agencies for their intended purpose, which is to help people get financing, I don't see how that was a negative amendment in the least. But I wanted to just go through this bill a little bit further. There were significantly more questions about the language of the bill, and it's quite clear that I'm not getting anywhere on some of the changes that I have talked about. But I think it's worth addressing some of them in the form of amendments to make sure that at least it's on the record that these changes do need to be made. On page 6 of the bill is the list continued from the previous page of situations that exempt the park owner from this policy that is before us. And I just thought of something rather interesting looking at this. One of those requirements is line 9, which says the mobile manufactured home park is comprised of fewer than 15 lots. Does this mean, through you, Madam President, if the owner of the park has less than 15 units, they do not have to go through this process through you?
Senator Moore.
Through you, Madam President, it does.
Senator Sampson.
Thank you, Madam President. Is there anything stopping someone from dividing their park that has more than 15 units into different entities that have less than 15 units? Through you, Madam President.
Senator Moore.
Through you, Madam President, there's nothing in this bill that stops that.
Senator Sampson.
Thank you, Madam President. So to me, that's something that should have been addressed in the bill. And again, it's all in fairness. My questions are not about trying to determine what's right or wrong with regard to who should be benefiting and who shouldn't be. It's just right or wrong, period. It's about whether or not we should be interfering with the rights of individuals to use their property that they worked for. We have constitutional provisions. We have constitutional protections against that sort of thing on purpose. And I don't believe anyone should be carved out of that, including the state government. So my next amendment, through you, Madam President, I have an LCO number 9081, and I'd ask once again for the clerk to please call that amendment and allow me to summarize.
Mr. Clerk.
LCO number 9081, Senate Amendment D.
Senator Sampson.
Thank you very much, Madam President. This is a very straightforward amendment. It simply removes what in our amended bill before us is line 152, which is subsection 8. The transfer is made by eminent domain. It removes that language. And what that language would do is it would prevent the state or the federal government, I guess, if they were to go ahead and take a piece of property by eminent domain, they would not have to follow the guidelines of this bill. And I just think that's wrong. I think that the state should have to comply just as much as any other owner would. I move adoption. Ask for a roll call vote.
Thank you. And we will have a roll call vote. Senator Moore.
Thank you, Madam President. I reject that amendment. Thank you.
Thank you. Will you remark further on the amendment? Will you remark further on the amendment? If not, I will open the voting machine. Mr. Clerk, please. Senator Sampson.
Thank you, Madam President. Another amendment and another party line vote. It reminds me of last night. I sincerely doubt that the amendments that are failing simply because they're not policy that people agree with. It's simply the source of that policy and the way that this place works. And I'm doing my best to try and change that, to make the minority recognized and part of the conversation, so that when we have input on bills, we actually get to see it realized. And for me, that was a pretty straightforward amendment. I mean, in order to vote no on the amendment, you have to believe that the state shouldn't be as responsible for its obligations as the citizens that we represent. And to me, that's just hard for anyone, for me to make sense of or to believe. I have another amendment, Madam President, that has to do with Section 3 that is about the conveyance tax. This amendment is LCO 9093. And once again, I ask the clerk to call this amendment, and I be allowed to summarize it.
Thank you. Mr. Clerk, would you please call the amendment?
LCO number 9.
A straightforward amendment would simply strike Section 3 of the bill. And for those listening, Section 3 is apparently part of the negotiation that we heard about earlier that says that if the owner of the park ends up selling to the unit owners, they can avoid paying municipal or state conveyance taxes. And I disagree with that. No one should avoid paying state or municipal conveyance taxes in a transaction unless we all get to avoid them, which I can hope and dream for in the future. But for now, as long as these state and municipal conveyance taxes exist, there's no reason why we should be rewarding someone for choosing one buyer over another by giving them a tax break. It speaks to the overall unfairness of the bill. And I bring it up because the original sections of the bill were very unfair to the park owner and to potential buyers. This amendment is unfair to other potential buyers because their offer does not include the benefit of avoiding conveyance taxes like the unit owner's offer might. And it's also unfair to every other taxpayer across the state or municipality, depending on which tax we're talking about. Because clearly, if you don't collect the tax on that transaction, that will artificially increase everyone else's taxes. So in an effort to show that my goal here is simply to stop interfering in the freedom of these folks to be able to engage in commerce on a level playing field and to stop the state government from inserting itself and taking sides and playing favorites, let's just get rid of this section. I move adoption, Madam President, and I'd like a roll call vote.
Thank you. We will have a roll call vote. And Senator Moore, would you?
The underlining bill regarding the conveyance fee, I don't see how this is fair to the rest of those of us.
35, total voting yea 12, total voting nay 23, absent not voting 1.
Amendment fails. Senator Sampson.
Thank you very much, Madam President. Since Section 3 remains in the bill, I figure I should talk about it for a moment. I've already expressed my frustration with the notion that we're negotiating incentives for various parties in the state to engage in certain types of behavior and transactions that the state clearly sees a benefit to, rather than simply allowing the citizens of our state to make their own choices and compete freely in the case of real property transactions. But I have a question. On lines 169 and 170, there's a line that says the sale requires the continued maintenance of the property as a mobile manufactured home park. And I find this fascinating because what that sentence refers to is the condition by which the sale or the conveyance tax would be waived for the seller. And my question is, through you, Madam President, what in the heck does the conveyance tax paid by the seller have to do with the continued maintenance of the property as a mobile manufactured home park. They have no control over that. That will take place only after the transaction and only after the tax would have been paid and is exempted. So how can anyone possibly know whether that maintenance will be continued and whether someone will live up to it? You've already given the benefit. Through you, Madam President.
Senator Moore.
Could we stand at ease for a moment, Madam President?
We can stand at ease. Senator Moore.
Thank you, Madam President. That section means that after the conveyance is waived, that they have to maintain it as a park. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. How can anyone know that's going to happen? And there's no time limit. How long do they have to maintain it as a park for? Through you, Madam President. Is it 1 minute, 1 hour, 1 day, 1 year?
Senator Moore.
Through you, Madam President, the residents will be the owners of the park, right? They will be responsible for maintaining it as a park. If this is sold, may I ask this question through you, Madam President? Are you asking about if they sell the property? Through you, Madam President.
Senator Sampson.
Thank you, Madam President. No, I'm asking about how this condition can be monitored. How can a condition be set for something that happens after the conveyance tax is waived? In other words, I'm sorry, I'll try and do a better job of asking the question, which is this section deals with the conveyance tax that would be normally paid by the seller of the park at the time that they close the transaction and give it to the new buyers, the unit owners. And I understand the desire of the proponents of this legislation to see the unit owners continue to use the park as a mobile home park and to maintain it. And it says continued maintenance on here. But the fact of the matter is they have nothing to do with this. This is an exemption for the seller, and it's being granted at the very moment they're taking possession of it. How can anyone know that they will continue to use it as a mobile home park beyond that very instant when the transaction takes place and the tax would be paid or, in this case, waived? Through you, Madam President.
Through you, Madam President.
Senator Moore, sorry.
Thank you. I apologize for over-talking you. I would, when you sell a piece of property, papers have to be filed. It's a mobile park. If it turns into something else, there would have to be some type of filing that said it's changed from that mobile park. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I don't know that that's true, but even if it assumes it was, then what? Do we go back and tell the seller that they have to pay the conveyance tax because the people that bought the park from him have changed their use of the property? Through you, Madam President.
Senator Moore.
Through you, Madam President. So when the park owners sell, they would be liable for the conveyance on the next sale. The conveyance waiver is only for this sale, not for future sales. Through you, Madam President.
Thank you, Senator Sampson.
Through you, Madam President, that's not correct. The language of the bill is explicit that it affects the seller of the mobile home park. Section 3 says an owner that sells, leases, or transfers, again, shall be exempt from the payment of any state or municipal conveyance tax, provided, and there are a few different provisions, but they're all separate. And number 2 is the sale requires the continued maintenance of the property as a mobile manufactured home park. The seller cannot guarantee that. The seller has no way to ensure that that will happen. And the state clearly, by drafting this bill the way they have, doesn't much care. But I do. I care because if we're exempting some folks from paying a conveyance tax, the rest of us are paying that tax. And I've already attempted to try and prevent that from happening. But now I'd just like to simply point out that there is no protection here for anyone. The supposed policy interest for the state is to benefit the unit owners in making a purchase, which I think is contrary to what we should be doing. We should be trying to create a level field and protect everyone's rights to make the purchase. But the policy purpose of the bill is to create that incentive and also to create an additional incentive for the seller to sell it to them by allowing the conveyance tax to be waived. But this condition has been added, which makes no sense. So, through you, Madam President, is there a way we can modify this language to take out this condition that cannot be monitored, that cannot be fulfilled in any way? Through you.
Senator Moore.
Through you, Madam President. Madam President, I am comfortable with the language that exists in the bill.
Senator Sampson.
Thank you very much. I appreciate that answer, and I can understand that you're comfortable with the language in the bill. Madam Chairman, let me just back up a little bit. We started on this bill several hours ago, and I have brought forward several concerns about the language in the bill. And let me just say that I've made my concerns about this policy known from the start. I don't like this policy. I don't find it to be in keeping with American tradition or the role of government, and I've been explicit about that. But that's only part of the equation for me. The other part of the equation is that if we're going to write a law, it ought to make sense. The language in the bill ought to be something that people can understand and follow. When we write a law and the people on the street that have to obey those laws can't understand what the heck we're trying to do because it's not clear or it doesn't make any sense, or it's just absurd on its face, we're not doing our job here correctly. So in an effort to try and help the majority from passing a bill that has these problems, even though I disagree with the policy, I brought these things forward. And maybe in some sense, it's important that I bring them up to make my case about the policy problems with the bill, but it is also to the benefit of the majority to understand that there are problems that need to be corrected if you're going to enact such a policy. Let's just address these really quickly while we're at it. Let's go back to the notice. Remember back in Section 2, it says that we're requiring the park owner to provide notice in the case of sale, lease, or transfer, which I gave up on that conversation because this thing is only about selling. And when you start adding leasing and transferring into the language, you create a bunch of different circumstances that are confusing. It should simply say sell. The other thing is that there's no purpose in requiring 3 different methods for notification. The bill says first-class mail with tracking. It says certified mail, return receipt requested, and then it says in person. I have an amendment, Madam President, to do what I said from the beginning of the bill, which is to fix that. Let's fix it. Let's make it just first-class mail. It's more than satisfactory. I have an amendment. It's LCO 9109. I asked the clerk to call it, and I more or less just summarized it, but I'll just speak briefly about what it does.
Thank you, Mr. Clerk.
LCO number 9109, Senate Amendment F.
Senator Sampson.
Thank you very much, Madam President. This amendment, all it does, as I said, is it changes the requirement for the owner to provide the notice to the unit owners in 3 formats: first-class mail with tracking, certified mail return receipt requested, and in person, which I read to mean service, a marshal or somebody. Now, I know we don't agree on that, but I think we did agree that there's no reason to have these 3 different things. Or would have been fine, instead of and, to include all 3 of these items. The amendment simply reduces the requirement to first-class mail. It's a very simple fix. If we believe that this would make the bill better, it's an up or down vote. Please, vote yes. This is a Senate bill. It hasn't even gone to the House yet. You know, there's no argument against trying to fix something that really is just something that is written poorly in the bill. I move adoption, Madam President. I ask for a roll call vote.
Thank you. We will have a roll call vote. Senator Moore, will you remark on the amendment?
Yes, Madam President, thank you. I think we reviewed some of these things, and I've never seen a perfect bill go through, but this is a reiteration of the bill that we would like to move, and I reject the amendment.
Senate Amendment F, Senate Bill 988. Total number voting 35, total voting yea 12, total voting nay 23, absent not voting 1.
Amendment fails. Senator Sampson.
Thank you very much, Madam President. Again, disappointed that something that is nothing more than a correction to a provision in the bill that doesn't really affect the policy very much at all, but I think would make things a lot more clear to the constituents that we represent. I'm going to offer one more amendment, Madam President. I'll just get right to it. And it's a similar situation where it's something I brought up earlier in the debate that troubles me because I don't think it's clear to our constituents. And we require laws to be clear. I mean, that's part of our tradition in America, that we don't empower people to enforce justice. We write our justice down so that it is the same for everyone, so that people can read it and understand what the law says and that it applies equally to all parties. This amendment is LCO 9094. And again, I ask the clerk to call the amendment. Thank you very much. And I'd be allowed to summarize.
Thank you, Mr. Clerk.
LCO number 9094, Senate Amendment G.
Senator Sampson, please do summarize.
Thank you very much, Madam President. This amendment removes the requirement that is in Section 2, I believe it is subsection A2, which is the requirement that the owner of the park issues a written notice, including a statement of the residents' rights under this section. And as I had mentioned earlier, I think that's a trap because I don't know that the seller is going to be familiar enough with determining what the seller's or the unit owner's rights are. And if they fail to live up to that requirement, I think that they could end up with some liability. And the best solution here is to make it clear what those rights are and make them available for everyone. So the amendment that's before us removes the requirement on the property owner to issue that statement and provide that list of rights, and instead charges the Commissioner of Housing to do so. And if you read on lines 22 through 25 of the amendment, it says, the Commissioner of Housing shall develop a statement of a residence or association of residents' rights under the section and the deadlines for exercising such rights, and post such statement on the Department of Housing internet website. This is a far better way to make policy. This is not writing a law into statute that almost no one's ever going to read or be aware of. Once we pass this today, I don't know that too many people are going to know about this, including the people that it directly impacts, the unit owners or park owners. Who's going to know to look this up? If you put it on the website, it's a public thing. It's right there on the Department of Housing website. Everyone knows what it is. It's easily accessible. It's easy to find. And it's clear. There's no guessing about what those rights are. It will be right there for people to read and to see and to follow. I move adoption of the amendment, Madam President. I encourage my colleagues to vote for this common sense amendment. Again, doesn't change the policy, fixes a lack of clarity.
Thank you. Will you remark further on the amendment, Senator Moore?
Thank you, Madam President. I reject the amendment and ask my colleagues to vote no. Thank you.
Thank you. Will you remark further on the amendment, Senator Moore?
Yes, I ask for a roll call vote, please.
Thank you. We will have a roll call vote. Will you remark further on the amendment? If not, the machine is open. Mr. Clerk, please.
Senate Amendment G of Senate Bill 988. Total number voting 35. Total voting yea 12. Total voting nay 23. Absent not voting 1.
Amendment fails. Senator Sampson.
Thank you, Madam President. I'm beginning to sense a bit of a pattern here. I'm tempted to actually ask the chairman if there's any amendment that I could offer that she might accept rather and suggest her colleagues support, but I won't go there and put her on the spot. But I hope that this conversation has illustrated the frustration of serving in a minority and trying to come up with compromise and bipartisanship on the policies that we put forward. There are certain elements, obviously, I don't expect the majority to work with me on. We have ideological differences, and I respect that. And they serve in the majority, and as long as they do, they get to move their agenda and impose their will. It's not always going to be like that. I should remind them that the pendulum of ideological power does swing back and forth, and sometimes rather suddenly. Not suddenly enough for me, but suddenly. At any rate, the things that are not in conflict when it comes to our ideological differences, that's another story, however. And for me, it's very difficult, especially when we're working on a Senate bill here in the Senate, where there's no delay. There's no real reason. I know we're near the end of the session and all, but there's no real reason not to accept an amendment that improves the bill. We're going to change it right here. It takes a moment. It takes the same amount of time to vote yes as it does to vote no on one of these amendments. And all it would do is encourage more bipartisanship and more compromise and better product at the end of the day. So it's very frustrating to continue to offer amendments where I know that I'm not even changing the importance of the policy of the bill for the proponents. I am just trying to fix things that are confusing or nonsensical. And to see those amendments go down on a party line, rejected out of hand. I put a lot of thought into my debates, Madam President. When I come up here, it's after I'm very prepared. I spend a lot of time reading this information and understanding what's going on. And as I've expressed many times before, I'm not on anyone's side except for everyone's side. I want to protect the rights of all of the people that we represent so that everyone has an equal opportunity in our society and is treated fairly and equally under our laws. And when I see bills like the one that is before us today, I find it very difficult to let it go without a strong fight. Because for me, this is pivotal. The stuff that is in here is important. These are not small changes. This is not just some tiny little around the edges, regulation that we're going to pass that affects mobile home parks. What we're doing here is changing the way our government has operated for its entire history. We're ignoring property rights on one hand. We're suggesting that the sanctity that we have always ascribed to people's ownership of things. And let me remind you that ownership doesn't happen by accident. Ownership comes from labor. It comes from the work of someone. Someone had to work to have the wealth to be able to own things. And when the state comes along and interferes with their ownership, it's wrong. It doesn't matter who it is. It's wrong for people to take things from one another, and it is especially wrong to use the power of government to do so. That should never happen. As I mentioned from the outset, we all take an oath, and our oath is not to decide who has more rights than others. That's not our oath. Our oath is to uphold the Constitution and protect everyone's rights. And if this bill was lopsided against the unit owners, I would be fighting it just as hard. But this bill is lopsided against the park owners. And is also lopsided against everyone else that might ever be in a position to purchase a park. Not only that, I think at the end of the day, it's going to end up with a negative result for our economy, for the future of mobile home parks, generally speaking, since fewer people are going to want to be in that industry based on the obstacles that are being created here today. And ultimately, that means less prosperity for people that live in mobile home parks. We're watching what happens when you have a government that is active in interfering with private contracts and the economy. It's called Connecticut. There's a reason why we're at the bottom on a lot of lists when it comes to economic opportunity and good places to do business. It's this. It's this. What we ought to be doing is finding ways to allow the market to work, to create opportunity for people. That's what we should be doing. I offered several amendments with that in mind. Let's get the information out there. Let's teach people how to go ahead and get financing to empower themselves. Instead, this bill says that some people have more rights than others. That's wrong, Madam President. I won't go through the entire thing because we've had a long conversation already, and I stated from the outset what my concerns were. But as simply as I can put it, this bill tells that owner of these properties that they do not have the right to dispose of them as they wish. And I want to just ask everyone a final question to ask yourself, which is pick anything you own. I don't care what it is. Whether it's a house, a business, a car, a precious item that you have. It doesn't even have to be valuable. But if the state came along and told you that you don't get to treat that item as if it's yours anymore, the state now has a say in how it's used, how it's sold, how it can be transferred. Is that right? Absolutely not. And the people that put their labor, their sweat and toil into achieving wealth enough to purchase things deserve to own them and to keep them. And their right to do so needs to be protected by this circle. This bill does the opposite of that. I encourage and I implore my colleagues, vote no on this bad piece of legislation that sets a terrible precedent.
Thank you, Senator Sampson.